Because we all know the colors that the current Speaker of Parliament wears, the political colors that he wears. And he may be influenced by the biases of his own political colors. Beyond that, he had a good refuge in the precedent set by Professor Mike Okwe in November 2020. And so I was not surprised. But I was so stunned by the argument I made that if we want to go by this issue of drawing conclusions from conduct in situations like this, we may not serve our democracy the way we want to do it. And it may lead to a point where
3FM 92.7,
which are purely legal, may find itself being dealt with politically.
I see. Now, if you read Article 97 of the Constitution, you're a lawyer. It says that if he leaves the party which he was at the time of his election to Parliament to join another party, or seeks to remain in Parliament as an independent member, or if he was elected a member of Parliament as an independent candidate and joins a political party, the Speaker used this as basis for his decision. There's no ambiguity here. It's so clear in terms of the written English. But as a lawyer, where would you say the Speaker faulted in his interpretation of these two provisions?
Thank you very much. What does the phrase or the clause seeks to remain in Parliament mean? That's where we must have proper interpretation. That area creates conditions of doubt. It is not for nothing that each Parliament has a name. We are in the 8th Parliament. What they are doing is only preparatory work for the 9th Parliament. So they seek to remain in their current statuses in the 8th Parliament. But by their conduct, they are sounding, if I say, their intention clearly to their political parties or to all, that in the 9th Parliament, they will seek to return to Parliament in different statuses.
3FM
in the case of
92.7
and Asante as independent MPs, and in the case of Amakwa Asante as Siama, Amakwa Siama as being sponsored by the NPP. So when we say seeks to remain where? In which Parliament? And so if it's about the 8th Parliament, they have not made any such communication. Is that not the case?
In terms of the 8th Parliament, no. But by filling those forms and the notice of poll being available at the Electoral Commission, that's what the Speaker says. They have given
the
intention.
Notice of poll and all those things are preparatory works for the 9th Parliament. That's what you must understand. Otherwise, there will be a hiatus between the 8th and the 9th Parliament. So these are preparatory works. Right? Because as at now, we know that Napo, for instance, would not return to Parliament. There is notice of poll for him to become vice president, right? But he seeks to remain in Parliament as MP for Malaysia. So let us look at it. It is the life of the Parliament that we are dealing with.
Professor Ransford Jampo has an opinion on this matter, and I read excerpts of it to you and then seek your comment. He says the law we are referring to was introduced in 1969, 1979, and 1992 constitutions to simply prohibit carpet crossing within the same parliament and does not concern an MP's intention for the next parliament. One can only appreciate this reasoning by understanding our political history that serves as the spirit that brought this law into being in the first place. So what's the historical antecedents of the law? Sorry. In 1958, following the passage of the notorious Preventative Detention Act, some opposition members were arrested and detained, including Victor Owusu and Ara Ramponsa. Buzia fled the country to avoid arrest and detention. Out of sheer fear, some MPs of the Northern People's Party, including Yakubu Tali, J.A. Brima, and the father of our current vice president and flag bearer of the NPP, Dr. Baumia, had to cross carpet to join the CPP in order to avoid the harassment and intimidation by 1960. The number of opposition in parliament had reduced from 32 to 16, while that of the CPP had increased to 88. It was with this enlarged strength in parliament that the CPP introduced the Republican Constitution. This law is about cross-capping. That's what Professor Jampo says. What do you say?
In fact, he couldn't have said it any better. And I couldn't have agreed with him any more than he has said it. You see, these days, in interpreting the law, especially interpreting the Constitution, we are allowed to even go through the preparatory works that were done to see what exactly the
spirit of the law,
exactly.
the drafters had in mind.
I think Professor Okwe was wrong in ousting Esiama at the time that he did. And I think Bagbin is also wrong. But you see, that's why I told you that sometimes it's about the politics of it.
3FM 92.7.
And so when we had the numbers, we didn't seem to care.
Right.
When that injustice and illegality was perpetrated against Esiama.
But none of you spoke up about it. None of you. In fact, there was jubilation on your side because it was okay.
That's why I'm saying that it was animated purely by politics and not necessarily the legality of it.
I see. But
so the history itself tells us that it is not for the preparatory works of a yet to be born parliament, but that it is when it happens during the life of that parliament. And I'm saying that in that regard, the most classic example we can give is that of Abraham Kufuor.
Right. I see. So both speakers got it wrong, but the decision has been taken. Do you think the court will overturn this decision by the Right Honourable Speaker of Parliament?
I would not second guess what the court does. But thankfully, the Constitution itself also states that final judicial power rests with the court. And when it comes to the interpretation of the Constitution, it is the sole prerogative of the Supreme Court. So let us just see what happens. Now that the condition of doubt has been created, it means that the work of the Supreme Court has been cut for it to deal with it. And so if they give the interpretation that such conduct must not be seen as cross-carpeting in the life of that parliament, and that if it is only seen as preparatory work, then the person should remain in parliament until
92.7.
his mandate is runs out at the end of the 4-year term. So be it. Then we will be guided by it.
I thank you very much indeed for your time.
You're welcome, sir.
The Honourable Alexander Kojokom Aban is a private legal practitioner, former member of Parliament for Gumar West. Joining me on the phone line again is Justice Abdullahi. He's a private legal practitioner with Crown Legal Consult. Counsel, good morning. Thank you for your time.
Good morning. Every time for God and country.
Great. Now, this pull and push in Parliament and the decision that has been taken, I just got off the phone with Lawyer Aban, who thinks that both Speaker Okwe and Speaker Bagbin got it wrong, and he awaits the interpretation of the Article 97, which was the basis of this decision by the Speaker, by the Supreme Court. What do you say?
I indeed agree with the position that Speaker Quay got it wrong. I think right from day one I have been making that point that relying on, and the basis for my disagreement with Speaker Quay is purely on the basis of the evidence he relied on, i.e., a letter communicated from the office of a political party,
right?
Expelling, orchestrated to expel the member of parliament. I think that was completely wrong, and that should not be part of our constitutional jurisprudence, not in any way, for us to allow political parties to hijack the parliamentary business and, as it were, push members of parliament to kowtow to the whims of the leaders or the ideologies of the political party outside of parliament. I think that members of parliament should be afforded the independence of mind and to serve to the best of their abilities, of course. But because the constitutional requirement of every member of parliament belonging to a single political party or not at all, the idea of losing your seat, that I completely support. And for that part, I think that parliamentary business has its own protocols and methods of dealing with people crossing carpets. And so reliance on internal parliamentary business to deal with such matters, as we witnessed yesterday, for me, is the most appropriate way of dealing with members of parliament who cross carpet, rather than relying on external bodies. It takes away the independence of parliament and the members of parliament from engaging in the business for which they were voted into offices for.
How do we undo this precedent, which has been reinforced by this decision by Speaker Bagbin? How do we go back?
Like I said, I only disagree with what Speaker Quay did, but not what with Speaker Bagbin did, because I see the two as completely different, because I see one as invoking the internal mechanisms of parliament in dealing with this matter, and the other as relying on political influence in dealing with the same issue or similar issue. So the two are separately, conventionally different and conceptually different. And indeed, I do not also see what Speaker Bagbin did as a reinforcement. And I think he rightly pointed it out when he said that even though there's a precedent, he's not bound by it. But I put it this other way, that the precedent is even different. That precedent is completely different from what happened yesterday.
Right.
And so if his basis for
how different is it? Help us to understand.
2.7.
Like I pointed out, because one relied on the influence of a political party to take a decision, and the other relied purely on parliamentary protocols and to do that. The two are conceptually completely different. Legally, they are different because one reinforces the independence of parliament and the cardinal principles of parliamentary business for engaging in their own activities, as enunciated in several authorities of the past, that activities of parliament must always remain a closed book to the rest of the world. Their outcome can question them, can challenge them, but not in their internal mechanisms. And these were reinforced even in the Justice Abdullahi and Attorney General case and the host of other celebrated cases before that judgment. And so it is better to deal with matters from that angle than sitting there one day. So imagine one day, because you disrespected the chairman of your political party, the next minute you're out of parliament. I do not think that is the kind of democracy you would want to build. So tomorrow, assuming you have a clash of whatever kind, either ego or any other, with the secretary of your political party, the next minute you're out of parliament because he probably doesn't like you, and so he writes to the speaker, please remove him, and you are removed. How can political parties have more powers than the electorate who elected the members of parliament into the office? I do not think that is the appropriate way of going about things. And so that is why I think that the two are separate and different, and so one cannot be a reinforcement of the other. And so if you are disagreeing with what Speaker Bagbin did, I do not think that disagreement, that there may be a reason for you to disagree, of course, and I respect that completely. But not because the two are similar. The two have no they have no similarities at all. I mean, as far as I'm concerned.
3FM
So,
92.7.
yes. Now, having said that, if you look at the merits of what the Speaker Bagbin did, I completely agree once again to the effect that the persons involved fell short of the requirements to be allowed to remain in Parliament. For several reasons. One being that their conduct the conduct being questioned is the conduct as at today. As at today, these persons, and that is what the constitutional provisions are really about. They are not future conduct.
Right.
They are current conduct. The current conduct is that these persons who are members of Parliament came on the ticket of a particular political party. As at today, we cannot say that they are still members of the political parties that brought them into office. And that is what the constitutional provision is really about.
I see.
The constitutional provision is not about their future conduct. It's about the current conduct and their past political parties.
They both speakers talk about loyalty, because if Justice Abdullahi was voted for on the ticket of Party A in constituency X to represent the people, he can't now, in the middle of his service to the nation and on behalf of his constituents, come then to say that he now belongs to Party B, but he still is MP for constituency X. That both speakers drew that analogy. Now my question is, how does the intention for the future affect your loyalty in practice for another tenure of Parliament? How?
Johnny, that's exactly what I just explained. That, you see, the moment you came into Parliament on the ticket of political party A,
right,
once a member of Parliament, you have taken active steps, not future steps, active steps, to represent the political party in Party B. Now, clearly from that moment, the moment you announced or filed the necessary processes to be a member of Parliament in the future Parliament on the ticket of a different political party, that process did not start in future. That process started today while still being a member of Parliament on behalf of political party A. Now, if you argue that these are future intentions, then it completely makes nonsense of the entire provision. Because what it means is that in that future, when we enter that future, there will be no political party B that you came into office with. It wouldn't exist. It completely makes nonsense of the entire G and H provisions in the Constitution reference to Article 97. Clearly, it wouldn't make sense. It's what lawyers may call the highest form of absurdity, if you argue it that way. And more so, when when all the political parties, in particular, have as part of their constitutional provisions a provision making you a member of those political parties before you can contest on their ticket. So the question is, at the point when the person was nominated by the political party today to contest tomorrow's election, which party was he a member of? This question must be answered by someone.
Right.
If you were, because you came into office, let's say on the ticket of the political NDC, today you have filed your nomination to contest an election for the political party B.
Right.
So as of today, which of these two political parties do you belong to?
Right.
This is a very simple question. Now, if you cannot say that you belong to political party A today, or you are saying that, as of today, you belong to political party A because it suits you, because you're a member of parliament for that political party. Meanwhile, the same today, you're a member of political party B because you are coming into office, because you are seeking to come into office tomorrow.
If you read the MPP's constitution, there's a provision in it that says that as soon as you either go independent, where there is a sponsored candidate of the party in that constituency, or you cross carpet to join another political party, where there is a candidate sponsored by the party in the constituency, automatically you lose your membership. All the three members of parliament who are now seeking to run independent, which notice of poll have been published by the MPP's constitutional provision, have lost their membership of the party. And so that is also another basis that was raised I remember by Speaker Okwe in the 7th of November 2020 ruling. So it comes back, okay, so on both sides, both the political parties' constitution and the national constitution are both saying the same thing but in different language. How then is there confusion?
The confusion clearly stems from the political fallout that this brings. I mean, obviously, it's the biggest embarrassment in the Fourth Republic to any president that for the first time, the political party in government is now the minority in parliament. Naturally, that is an embarrassment. And it's not just an embarrassment. It also brings a lot of trouble, of compromises on the party in government. Now you are compelled to compromise on literally everything you wish to do. But without compromise, you cannot make any step. You may not even be able to withdraw a penny from the public purse. So you are compelled, against your wishes and your will, to now compromise. Sit down with the person you saw as your enemy today. It has to be your friend, against your own will. Naturally, these are not pleasant circumstances to any person in government. And, I mean, we can't be oblivious of these facts. I mean, this is a fact. And just imagine the number of books that the guy, those in, the NDC side in particular, let's not be specific, the number of books they can open just by their majority.
Right.
They're literally going to head almost every single committee in Parliament. They would wield so much authority and so much influence. And that's not the kind of thing you would want as a president. And so it definitely has huge implications, albeit we have barely 3 months for the current president to remain in office. And so it is a difficult situation, and we need to admit that. But it is what we have at the moment. And it is what I have been praying for, that one day we get this kind of thing. I mean, Johnny, you know my views on this, that I've always prayed for having either equality in Parliament or the minority of any government, the minority party leading, taking charge of Parliament when the executive is someone else.
Well, we had this equality because we had 137 plus the MP for Fomena Esiama, who now has been shown the exit because he wants to contest on the ticket of the MPP. And really, Ghanaians, if you listen to most Ghanaians, they say it was much ado really about nothing because they expected some more middle ground, some more, things that were not, heavily partisan. But it really didn't happen the way they wanted it.
And I fully endorse that view. I think this parliament has been possibly the most disappointing parliament, despite the numbers. And I say this on the grounds of the numbers that we had. I thought that the numbers were so good that we could do so much for this country, for the first time, without being partisan. But I think, in fact, most members of parliament would even admit of this fact that they have not lived up to expectations. So I do not think that that assessment of this particular parliament is wrong. But our magic is really with the numbers. If we make good use of the numbers, if we had made good use of the numbers, I think we probably would have done better and given Ghanaians something more than what we are currently witnessing. And so, admittedly, the numbers hasn't been. We could have used the numbers way better to the advantage of Ghanaians rather than what we are currently experiencing. But the circumstances has changed a little. But significant change has come with these numbers because let's remember that even though we had equal numbers, Esiama decided to join his previous political party.
Right.
Business, not on. And so that one number made a lot of difference. And so the same one number is what we have currently. And I expect and pray that it makes a lot of difference within the 3 months that we have. But I think we need to put it on record that Esiama will go down in history as the most famous member of parliament for having been ousted twice.
Yes.
The same seat.
Yes.
I think his place in parliamentary democracy can never be challenged by anyone. So I think, for good or for bad reasons,
in fact, he was kicked out the first time. He came back the second time and became a deputy speaker. And then now he has been kicked out.
Even as a deputy?
Yes, as a deputy speaker.
Even as a deputy speaker?
Yes.
And I think it's just a remarkable feat.
He's a living legend. He's a living legend.
In fact, he's a legend in political democracy.
Now, Council, before I let you go, when can you say that one has crossed carpet? That clarity must be put out there so we all understand what it means to have crossed carpet.
So good. So this is where I try to draw the linkage that drawing the linkage between future intentions and current happenings. So at the point where a person, and which is why I went back once again to look at the political parties, their own constitutional provisions and all of that. So at what point, for instance, assuming the person is a contestant on the ticket of a political party, the question is, at what point was the person allowed to even file nomination with the political party that he's moving to contest on their ticket? My view is that the moment he was allowed to file his nomination, that would be the only basis, unless of course we're able to gather information as to his membership at the time, or either before he filed the nomination or at the time of filing the nomination. If you have evidence that he has joined a political party, I think that should suffice to conclude that indeed he's no longer a member of the political party that brought him into office, but now a member of the political party that he's seeking to rely on to contest for the next election. And so, two issues here. First, either at the time that he filed to be a member of that political party. Now, the question here is, some political parties have some discretionary power to allow you to contest even without being a member of it. And so you may not necessarily get evidence of it at that point. Now, then the argument would then shift to that at what point again. Now, that point would be either at the time he filed his nomination with that political party, or at the time he filed his nomination with the Electoral Commission. At these 2 points, in addition to the first one, you would have evidence that now that he has filed appropriate processes, he has taken all the all the steps required in law to be a member of that party, and to be a member of a different political party. And so from that moment, he can no longer be said to be a member of the political party that brought him into office. So it is only at these 3 moments, any of these 3 moments, that you can confidently say that you have enough evidence to expel that member of parliament from office for having crossed carpet. Now, it is a different thing when the person is becoming an independent candidate, because there will be no evidence. Let's remember that. There will be no evidence that he's now an independent candidate, because he will not file any nomination with any political party. Neither would he file membership of any non-existent political party. And so, how then do we come to this conclusion? That is where, once again, filing his forms with the Electoral Commission then becomes the only sources of evidence. But the moment you file with the Electoral Commission, you are effectively now an independent member of parliament.
Right.
And because that is the only evidence that we have. Because, in fact, that is where people talking about future intentions, this is where they will be right. Because the future intentions, they did not, these persons would not have had any evidence that they might have said it, they might have done all kinds of things, might have even posted bills all over the world. But that would not be sufficient evidence, because that would then be only a future intention. But once a person files with the Electoral Commission, it's no longer a future intention. It's no longer a future intention.
Right.
He has effectively crossed carpet at that moment.
Okay.
And so it will be sufficient for us to make a decision as to whether to expel that member of parliament or not. Now, for me, the biggest difficulty here is whether the discussion to expel should remain with the speaker, with a particular speaker sitting.
Okay, and I was coming back to that. If you give me a 30-second answer, because Mustafa Gbande is joining us on the other line, so we can engage him as well. 30 seconds.
I think that's an issue that we all need to think about.
Well,
who should hold the hammer to make that decision?
Okay, the gavel.
I think it's something we can all think about.
Now, some lawyers have said that the Supreme Court should be the one to hold the gavel on this matter. But let me ask you, does the majority Afenyo Marking and his team, do they have any business going to the Supreme Court when it is so glaring? Article 97, the clauses, the provisions in there, what the Speaker Bagbin said, what Speaker Kwe has done, the President. Do they have any business going to court at all? 30 seconds answer for me, please.
Johnny, whether it's for mischievous reasons or for a genuine reason, I think going to the court is never a bad thing. It would help us. Whatever decision that comes out would be a good guide to all of us in future. So I don't think there's anything wrong with that.
Thank you.
It couldn't have been a basis to stop what happened to happen.
Thank you very much, Justice Abdullahi, legal practitioner, also a law lecturer at the UPSA. We're grateful that you spent your morning with us. Thank you.
Thank you so much.
Mustafa Gbande is the Deputy General Secretary of the NDC. Mustafa, thank you for your time and your patience. Good morning.
Good morning, and thank you for having me.
Your side is now the majority side, according to the members of Parliament on your party's ticket in Parliament. How does that make you feel?
Thank you very much. Beyond the ultimate prize, which will permanently
3FM
grant the people of this country some relief from the burdened political corruption, mismanagement, ungovernable system that we have, led by the current crop of MPP and His Excellency Nana Akufo-Addo. I think that what has happened in Parliament in a short term gives hope to the people of Ghana, because in the next few months, this government would like to finish everything in the coffers. And so for the first time in the history of our country, I think the minority is majority, total majority, and have what you call absolute control of Parliament. It puts a bit of checks, it puts a bit of governmental brakes on the unrepentant President Akufo-Addo's regime and a government that has a pageantry to eat all the meat, including the bones. And so for me, it's a good thing. It's also good to teach all of us, the political parties, some lessons, political lessons. Because when people jump into our boots and we give them the opportunity, leverage on the party, use the party, get to where they have to get to, sometimes, owing to their own greed and selfishness, these things happen. Other times, bad leadership also lead to some of these shortfalls that in the long time affect the strategic interests of the political party. So for me, it offers a classroom note for us in the NDC.
3FM,
and also it gives me hope as far as the country is concerned. We have to clearly examine individuals that we take to Parliament, their level of commitment, their level of loyalty, and also be watchful their various conduct and how we treat our members so that we don't have this level of degeneration. I think the MPP has been integrated over time, so divided, so disenfranchised in their own consensus building. Today we have a political party out of the MPP led by Honorable Alan Kojo Tremanting. Whichever way you see it, it is a crack, a major crack within the MPP. Today we have 3 members of Parliament who are not clearly on the side of the party, even though one of them is now coming in after he left the booth in the last election. It just shows that a group that cannot be trusted with power, it just shows a group that cannot sit to agree on the way forward.
But you also have one person leaving your fold to run independent.
When you are in opposition, you are politically stressed, and so you can experience some of these challenges. But when you are in power, there's a lot of things that power can do. There are a lot of things that power cannot do. When you are in power, you should be able to mitigate some of your cracks and problems. Today, as we speak, and I can tell you for free, most of our campaign activities, most of the things that we do, are highly supported by MPP members. MPP members, including ministers and including senior members of the MPP and the grassroots, who believe that clearly they think that their party needs some level of rebranding, reorganization. Nanado have exposed the party to what it has never been before. Today, if you mention the NDC, the MPP, what comes into your mind as fraud, is lie, is corruption, is stealing, destruction of our environment, destruction of our country, collapse of our economy, stealing of public money, sharing of public land. That is what immediately comes into a mind of someone who is having a conversation. And this is not good for a political party. And so most people within the party believe that it is good for the party itself to proceed into opposition so that they can take their party from this, if you call, fraudulent scheme that Nanado have put in place. It has never been a genuine force. In the NDC, we are having one, and you have seen a litany of activities that the party has taken to intervene, even to the point that we nullified, a genuine, legitimately conducted parliamentary election. We nullified it just for the sake of peace. It is only the case that the sitting MP participated in that election, filed nominations, then during vetting, he was caught to have forged documents.
Right.
And then he himself voluntarily exited. So that you can see, even now that he is on independence, the party have not expelled him. We still are beating time to give enough room for reconciliation, even though these things are happening. So clearly you can see the strategic point of view or the standpoint of the NDC in dealing with this matter as compared to the MPP, where most of these cracks are coming because persons have become greedy. The Jubilee House is imposing and removing others. Persons have become sensitive to disagreement, and that is what is affecting the MPP today.
I see. Now let's look at the politics of it. What could your side in Parliament really do with 3 months if you are giving the majority side of the group? And mind you, Mr. Siama is also a deputy speaker, so that means that deputy speakership may have to come to you. What could you possibly do within this short period?
What the MPP and Nanado has used force to delay is what is manifesting. And it's just application of precedent and logic. What it is that Ghanaians, in their own intent, didn't want President Akufo-Addo to have anything to do with governance, except that they rigged and imposed themselves. So even 2 days is enough for government to steal a lot of money. And so if you have this change, it can pull the brakes. Ghanaians cannot hold NDC MPs in Parliament responsible if they sit aloof and allow government to do or pass any bill in Parliament that subvert or that works against the interests of the people of Ghana. And I think that it places much more burden of responsibility on the NDC side to hold this government to proper accountability. And I would have wished that in a few days there should be an eminent and immediate application of impeachment against President Akufo-Addo for all the atrocities he has committed. He should not become a former president who at least there have not been an impeachment process against.
Are you saying that are you saying that the NDC in Parliament is considering impeachment now that you have majority in Parliament?
I'm saying that I would have wished that with immediate effect by next week, an application for impeachment is moved and commenced to get Nanado impeached as president, the worst and most corrupt president who have supervised the destruction of our environment and our vegetation. President Akufo-Addo and his appointees must be held jointly liable for the destruction of our forest reserve and our water bodies. He is the first president who has issued licenses for people to go and mine in the forest reserve, knowing very well that our river bodies and our streams flow out of our forest reserves. There was no way one will contemplate that you can mine in the forest reserve without affecting the ecology of the forest, which included our water bodies. The small-scale miners who are moving around have further exposed this government. You see them arresting people on the river bodies. Where is the Galamsok, the team made up of police and the military that the president ordered last week to go? Where are they? That we have to depend on small-scale miners whose names are innocently dragged on this matter to go and be defending the republic. Where is President Akufo-Addo? And so an impeachment should be commenced against him immediately. And I mean, President Akufo-Addo should not end his 8-year term without facing an impeachment. That would be a great disservice to the people of this country. And I think the NDC majority side now should be able to start something like that.
Now, the Honorable Afenyo Marking says that your side in Parliament has conspired with the Speaker of Parliament to bring confusion into the House. What's your response?
I normally become very hesitant to comment on Afenyo Marking because his arrogant posturing as a young man is not good for his own future.
Oh, why do you say that? Why do you say that?
The way he speaks, his posture and everything is unresembling of a lawyer who is well-natured and trained.
Are you confusing confidence for arrogance?
Well, no. I watched him yesterday. That's not confident. I'm a very confident person. But
right.
Your words, the assemblage of your words has a meaning. And I think that somebody should advise him to tread cautiously. If he likes, they should completely exit Parliament. Ghana will move on. MPP have done that before. This is not the first time they will boycott Parliament. They will be the same government that cannot introduce business. They should work out. What it is that the reality is that as we stand today, 4 seats are vacant. And the MPP cannot do anything about it. You can't eat your cake and have it. So ignore the rants and arrogant, disrespectful posturing of Afenyo Marking and let us move forward. We have to move a nation forward. Ghana must be moved forward. A country must be rebuilt. An economy must be rebuilt. The consequence of the damage caused by President Akufo-Addo is that innocent Ghanaians are dying, innocent people are suffering, innocent businesses are getting collapsed. There is no future for our children. That, for me, should be a priority for you as a journalist, for me as a young politician, and for every Ghanaian who will vote. The most important thing is that we must vote these people out of power, and never again should we have any brigade of this sort close to governance in this country. The impunity, the arrogance, the appetite for stealing has been overwhelming that we should never allow it to happen to our country.
Has the NDC taken a decision on who becomes Deputy Speaker now that you have the majority group in Parliament?
I want to believe so, that leadership is engaging with party leadership, and I think that some of these things will be factional. I'm sure that my boss and the national chairman will be keenly involved in this and with the flag bearer to ensure that by Tuesday, the NDC publicly and overwhelmingly is supported to take majority. I mean, they can go to court for all I care. The most important thing is that there's a change. The judiciary cannot undermine and subvert the dictates of the 1992 Constitution. And for me, I stand with the rule of law, I stand with the Constitution, and I stand with every principle that will ensure that people do not take the nation for granted. People do not allow their pageantry for power and double standards to override what our laws mean. You can't go to independence, cross carpet, and think that you should remain in your position. When they were sacking the first MP, what were they thinking? Their own party member, they did it. Now, some of their own party members and the other side, Afenyo Marking is making noise about it. Please disregard him and let's move on.
Some fear that your side, giving the opportunity and the power that you now have, will just be frustrating the executive and nothing more. What do you say to that?
It's not about frustration. This government is a crime scene. And if there's anything to protect the state and the interest of the state, I think that it is something Ghanaians have waited for a long time. If it is going to happen now, I think that, voila, we must be very grateful that it is happening. What is important is that we must ensure that what is left is amply protected. You know, if we are able to file an impeachment against President Akufo-Addo, I think it will be something that Ghanaians will be very excited of, and they will commend the now majority members for that action. We will not just frustrate the government. We will hold the government to the highest level of standard of governmental responsible behavior, so that they are not able to do what they did when they had majority to their side. And I think that we should be supported to do that. It's prudent, it's necessary, it's important that we do that to safeguard our country. Anything Akufo-Addo, anything Bawumia is a threat to the stability of this nation in terms of economy, in terms of our financial, and in terms of our resources. Their appetite to arrogate national interest to their micro interest is so high that today, if the MPP goes to opposition, the biggest loser is President Akufo-Addo. Because for all intents and purposes, Dr. Mahmoud Bawumia does not have a presidential ambition. Everything about him is a cover-up to protect and preserve the atrocities and the commitments of President Akufo-Addo. So a vote for Dr. Mahmoud Bawumia is not MPP, but a vote to prolong and preserve the bad governance and nature of President Akufo-Addo. And that is why all of us, whether you are NDC, you are MPP, we must be Ghanaian for the first time to stage this democratic change that will liberate our country and set it free after independence.
All right. Mustafa Gbande, thank you very much indeed for your time. We're grateful that you spent your morning with us.
I'm grateful, my brother. Have a nice day.
You too, sir. Mustafa Gbande is the Deputy General Secretary of the NDC. We reached out to the NPP's Director of Communications, Richard Anyagba, who says that, well, because of the matter that is heading to court, he doesn't want to make any statements. He would rather wait for the court to bring its verdict, and then he can comment on it. With some 18 minutes after 9 here on 3FM 92.7, listen to Alexander Apenyomarking, MP for Efutu. All right, listen to him.
Majority leader, still majority leader, to address you on the communication that just came from the speaker. So may we listen to the majority leader.
All right, so we've just witnessed a conspiracy between the speaker and the minority to bring confusion in the House. It is clear that Mr. Speaker avoided service of the writ to do the bidding of the NDC. It's so clear, but we believe in the law. We, as the majority caucus, immediately are boycotting Parliament until this matter is determined by the Supreme Court. The Speaker has no right to interpret the Constitution, and it is so clear that what he did was to give advantage to the NDC and do the bidding of the NDC. We are not going to go further to litigate. We have a process at the court. We'll follow it up. If the court makes a pronouncement, we'll respect the orders of the court. But because we believe that the issues we have raised are issues for interpretation.